All right, thanks to everyone for joining us for this first rulemaking committee meeting of the fall. I'm going to begin with the roll call. I'm going to call two rolls. The first will be the names of committee members and their alternates. After each name is called, the person should say here so we can make sure their mics are working. The second roll will be the names of ACUS members who are not on the committee and their alternates. After each name is called, the person should say here so we can make sure their mics are working again. I won't call members of the public who don't have speaking privileges. And I don't believe we have any members of the public, so that'll make things easy. All right, first roll is the names of committee members. Emily Bremer.
Here.
Amy Bunk.
Here.
Stephanie Davis.
Here.
Andrew Emery.
Here.
Bill Funk.
Here.
Courtney Mallon for Chris Huey.
Here.
Hillary Duke for Dave Liebman. Hillary, are you there? Okay. Elizabeth McFadden.
Here.
Nina Mendelson.
Here.
Elena Ness. Oh, I'm sorry, that's Sandra Miracle for Elena Ness. Oh, my apologies. Do we have Sandra?
Yes, here.
Great.
Yes, here.
Mitch Plave.
Here.
Great. David Pritzker.
Here.
Paul Ray.
Here.
Our committee chair, Bertrand Ross.
I am here.
Lon Smith.
Here.
Tony Verona. Oh yeah, actually, you know what? I just got an email saying he is unavailable today. Hopefully we can see him next time. He's a new member. Daniel Weiss.
Here.
Great. Miriam Vincent.
Here.
Great. Okay, so now for the non-committee members. Jeff Lubbers. Jeff, going once, going twice. All right, hopefully you can join later. Matt Weiner.
I'm here, thank you.
Great. Ron Levin.
I'm here.
Great. Who's next? Annalise Marchessault, alternate for Dan Cohen. Annalise, are you there? Okay. Alex Goodenough. I think I saw Alex.
Here.
Great. Kirti Datla. All right. We have a few alternates for Susan Davies. I'm not sure if anybody or all of them are on the line, but do we have Kevin Jones, Robert Hinchman, or Christina Greer?
Bob Hinchman's here.
Great. Anyone else from DOJ? All right, Bob, I'm glad we've got you. And then, of course, we've got our consultant, Mark Squillace.
Here.
All right. Did I not call anyone, either committee members or alternates, or non-committee members or alternates?
Hi, Ben. This is Noelle Green. I'm standing in for Helen Serasio. I don't know if she had a chance to let you know of the change in her plan.
Oh, no, but that's great. Okay, so we'll have you as, do we have you as alternate then for Helen?
That's right.
Okay, great. All right. Anybody else? All right. Then I'll turn it over to our chair, Andy Foyce, for some brief opening remarks. Andy?
Thanks, Ben. Good morning, everyone. I, too, welcome you to this first regular rulemaking committee meeting of the fall cycle. I think we have a strong draft recommendation for you to work from today. This is a subject that you ACUS veterans know is something that ACUS has focused on several times over the years in our efforts to help agencies engage more deeply and fully with the public in all of their administrative functions. I want to just thank everyone involved, starting with every member of this committee and everyone who's here for your volunteer work. We appreciate you doing this for us. Thank, of course, our chair, Bertrell, for his excellent work and contributions over the years and on this project so far. Thank you to consultant Mark and to Ben who has led this whole effort so far. So that's all for me. I look forward to the work, and you know, maybe we can get this done in 2 meetings, maybe 3. But either way, I'm sure you all agree that it is the quality over the number of meetings which you all have always concentrated on. So thanks very much, and I look forward to the discussion and the work. Ben?
All right, thanks, Andy. I like your hopefulness that we can get this done quickly. We'll see. So next, I'll turn it over to Bertrand for meeting protocols. Bertrand, the floor is yours.
Okay, thanks, Ben, and thanks, Andy, for the introduction to the meeting. So please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Committee on Rulemaking, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. So at this point, I will turn it over to Mark Squillace, who will provide a high-level overview of the report he submitted for this recommendation, and then we'll get started on a review and deliberation on the recommendations. Mark?
Thanks so much, Bertrand. Appreciate your comments and look forward to the discussion. Let me also begin by thanking Ben Burkill for all his tremendous support for this project. I don't think I could have done this without him, and so I really appreciate his efforts here. And I look forward to our discussion today. Obviously, this is a subject of interest to all of us, and I hear that a lot of you I know have written about these issues, and looking forward to hearing what you have to say about the draft report. Let me begin by just acknowledging that notice and comment rulemaking has become increasingly complex. We all know that, I think, and it's not surprising, I suppose, given that we're seeing more and more use of the good cause exemption to avoid at least traditional notice and comment. I was surprised, frankly, in doing the research to see the GAO report, which indicates that even 35% of our major rules are going through a good cause exemption, mostly through the IFR kind of process. So that's, I think, surprising, and it raises some issues I think that we ought to discuss. Just to be clear, of course, the things we're going to talk about today involve some level of notice and comment, but of course, if you're exercising the exemption properly, you don't actually need to do any notice and comment. So the interim final rule and the direct final rule that we'll talk about today don't necessarily require the sort of notice and comment processes that they involve. And so that is an interesting aspect of what's been happening with this process. I want to just also acknowledge that the idea of post-promulgation comments, as is done in the interim final rule, to my mind at least, seems a lot less meaningful and effective than allowing for comments in advance of the rulemaking. But I also want to acknowledge that courts seem increasingly comfortable with agencies using this practice. Most of you, I'm sure, are familiar with the Little Sisters of the Poor case, recently decided by the Supreme Court. And I was frankly taken aback a bit by the court's decision in that case, written by Justice Thomas, which I think suggests that IFRs essentially satisfy the notice and comment process. And so the court doesn't even appear to look into the good cause claim that was made in that particular case. Of course, if you take little sisters to its logical extreme, it seems to me that agencies could use IFRs for all their rules and they wouldn't need to justify it with a good cause exemption. I don't think that's what the court meant, but I was surprised, frankly, that there was no concurring or dissenting opinion that would have pointed that out. I want to also sort of make clear that from my perspective, it's really important that we emphasize streamlining of rulemaking. Agency practices are, I think, cumbersome and sometimes problematic. And so I think the use of the good cause exemption is not a bad thing. We ought to support and encourage its use where it's appropriate. But I also believe that where possible, we should follow pre-promulgation notice and comment kinds of processes to the fullest extent possible. So let me just briefly outline a few recommendations that I think should obtain in this particular case. Before doing that, I should also acknowledge, as I think Bertrand mentioned, there's been a lot of work in this area before, 2 previous ACUS reports, an ABA report, the GAO report that I mentioned, and many of you and other legal commentators have offered ideas. And so I'm not writing on a blank slate here. I realize that, and I've borrowed freely from all those earlier efforts. So my first recommendation, I guess, would be that we think about how we can develop guidelines that would be recognized across government agencies. I've suggested in the report, in the draft report, that perhaps the president could issue an executive order, or perhaps an agency that had a situation or an ability to oversee rulemaking like OIRA or Justice could issue guidance that would help guide agency practices for using the good cause exemption. I think that would help to ensure uniform application across the government, and that strikes me as a good idea. I also think that we ought to, if there is sort of guidance that's offered, there ought to be definitions of the key terms. Now, there's general acceptance, I think, about what an IFR is, what a DFR is, but I think fleshing those out a bit and maybe thinking about the best way to approach those would be a good idea. For example, in the context of IFRs, there's not a clear agreement about finalizing those IFRs. We ran across a few agencies that had let them languish for a number of years. OIRA didn't seem putting too much pressure on the agencies to correct that problem. So maybe defining an IFR so that it would expire perhaps after a year, maybe with a possible extension from OIRA if that was appropriate, but certainly a definition that could help clarify those kinds of issues. And also, as has been happening somewhat now with respect to direct final rules, the idea of issuing a proposed rule alongside it might make some sense. I've even suggested that maybe a DFR could be converted to an IFR in an appropriate circumstance. I'm interested in sort of feedback on that. I'm not sure that's the best idea, but certainly there are some arguments in favor of doing something like that. Finally, I want to just sort of make the point that I was surprised, as I said earlier, that these IFRs and DFRs are sometimes used for major rules. Now, I'm not suggesting that it's always inappropriate to use an IFR in particular for a major rule. Obviously, there are emergencies that may threaten public health or safety that would warrant this. Maybe there's a situation where a major rule doesn't actually affect third parties in any significant way, but I still think we ought to be very cautious about using IFRs in particular in the context of major rules. One last point I guess I'd like to make is that, and this I think comes out in the ACUS draft recommendations, agencies, I think, clearly have an obligation to respond in a timely way to public comments that they receive. I think they should do that on the record. And my sense is that's not always happening. As I mentioned, IFRs sometimes languish in agencies, and if there's not a timely response to comments that are received, I think those comments really just fall by the wayside. The same with DFRs to some extent. I mean, there are situations where maybe the agency gets comments, maybe they consider them insignificant, and so they don't decide to pull the rule, but maybe some response to those supposedly insignificant comments would be useful to finalize the recommendation. Okay, that's all I had for now, but I'm really looking forward to hearing your comments and having a discussion. Thanks very much.
Thank you so much, Mark, for that review of the report. We will proceed as we ordinarily do, which we'll work through the recommendations one by one, line by line in certain cases. And then we will return to the preamble, probably not at our next meeting. Now, for today's meeting, we received 5 set of comments. And I just want to just briefly say something about those comments. So we have comments from Jeff Lubbers and Miriam Vincent that are line-specific comments that we will turn to when we reach those lines of the recommendation, and they're embedded within there. And then there's other comments from Michael Hertz, who also has line-specific comments as well. There's comments from Ron Levin and Nina Mendelsohn that are, I think, most relevant to direct final rulemaking. And so we will turn to the issue raised by Ron Levin at the point at which we reach direct final rulemaking discussion, which I think is recommendation 6, if I'm remembering correctly, if that's okay. And then Michael Hertz also has a broader comment that I think are most relevant to paragraphs 6 through 9. Unfortunately, he's not able to make it here today, but we have his comments in the track changes boxes, or the comment boxes next to the document that you guys see. So there's a lot to work through. If for whatever reason we reach the line at which your comment is relevant and we don't have it embedded in the document, and you had a comment on that particular line, please raise your hand, use the hand raise feature, and we'll be for sure to call on you. Now, the focus is again on public engagement. When agencies use the good cause exemption, and the recommendations are focused on that. There are important issues that are raised in the report with respect to guidance on good cause exemptions and definition of key terms that Mark has referred to. And so part of our committee deliberation will be to assess where and how those recommendations fit into this report, which is focused on public engagement in cases in which the agency relies on or invokes the good cause exemption. Okay, are there any initial questions or comments before we initiate the process of the line-by-line assessment?
And I just wanted to jump in real quickly to make sure everybody can still see the document okay.
We can. Is it possible? I don't know if my screen and are you doing, yeah, no, for some reason. And you're doing the share screen function.
Yeah,
on here?
I'm sharing the document through Zoom, not my screen.
Oh, I see. Okay. The only thing, okay, I'm good.
If
Okay, so
folks
let me
can
start. Everybody could see. Is anybody having issues before I turn to Bill and Ron with some initial comments? Okay, we're good. Okay, so let me turn to Bill.
Thanks, Bertrell. And Mark, I thought the report was fantastic. And I strongly agree with you that we ought to have definitions. And I didn't find nice, clear definitions in the recommendation, at least not set up as sort of an introductory or final thing. But and one definition I think we ought to have and use is the final no comment rule, and a place to discuss when that's appropriate to issue a final no comment rule, which you spend some time with in your report, but doesn't appear to appear in the recommendation. In addition, I think another thing that we need to look at is temporary rules that come out and are temporary when they're adopted, and how that might affect either direct final rulemaking, final no comment rules, or interim final rules. And then I just want to say about Little Sisters is that I see Little Sisters as saying that if you adopt a final rule, and you're challenging the final rule, then the good cause exception is sort of falls out of it. But especially for all those interim final rules that the agency never finalizes, then they're certainly subject to judicial challenges whether or not the good cause exception was appropriate. So I don't think Little Sisters necessarily is the death knell for notice and comment rulemaking, or leaves interim final rules as something that people can just do all the time. So those are my general comments, but I really think the idea of definitions up front would be a good idea.
Before I turn to Ron, let me just see if Mark has any responses to what Bill said.
No, that was very helpful. It'd be interesting to talk more about Little Sisters. There's some interesting language there that I suppose could be read in different ways, but I'm still skeptical about what was said. And I wish one of the other justices had clarified, at least made some comments about what Justice Thomas says in the majority opinion there. But thanks.
Okay, thanks, Mark. Ron.
Yeah, so I agree with Bill about Little Sisters. And we can get to that in due course. But the general comment I wanted to make is that I think the prior recommendations in this area, 83-2 and 1995-4, distinguish sharply between direct final rulemaking and interim final rulemaking. And I think they were correct in treating them as different animals. And I think this draft goes down the road, the wrong road, in a number of places because it tries to mush them together under a concept of good cause rulemaking. They are really different, and it's hard to generalize properly about the broad category because there are different implications for the two types of procedure. And we can talk about them one by one, but just to highlight one way in which that's true, I don't believe there's any justification whatever for public outreach with regard to a direct final rule. This is a rule that is so trivial that the agency thinks it isn't even worth soliciting public comment on. And yet you would go out and try to scare up comments from other people, from interested groups, focus groups, listening sessions. None of that is necessary. It's too trivial by definition. And the way you find out whether you were wrong about saying public comments aren't necessary is simply to put it through the process. And if anybody objects with a serious comment, the direct final rule fails. That's as much feedback as you need to know whether this process was properly invoked. So it's a really different animal from the interim final rulemaking area, where I can understand their arguments for public outreach of various kinds. So I have this point to make in a couple of contexts, but I just wanted to emphasize that there's a lot of language here about good cause rulemaking that I think needs to be examined closely to see whether it applies equally to the two subspecies.
That's very helpful, Ron. Thank you for that comment. So it seems to me, given that our focus is on public engagement, and the point you're making is that there's even different forms of public engagement that would be appropriate with respect to interim final rules and direct final rules. And so that needs to be accounted for in the recommendations is how I'm hearing you.
Right. The only public engagement you need is what is already inherent in the process.
Right. Thanks, Ron. Emily.
So I agree that direct final rules and interim final rules are different and should be treated differently. And that's one of the reasons I had a skeptical reaction to the suggestion that if an agency gets adverse comments, they should withdraw a direct final rule and then have the option of issuing an interim final rule. To me, it seems like if it should have been an interim final rule, then that's what it should have been in the first place. And I think blending them together in that way and encouraging agencies to think of them in that sort of more blended fashion will sort of blur the lines between the two devices, and which is why I'm sort of skeptical of adding that kind of third option to what to do in the event of a significant adverse comment on a direct final rule.
Mark, that refers to a point that you made in your comments. Do you have a response?
Right. Thanks, Emily. I tend to agree with you. I mean, I'm a little skeptical about the idea of shifting from a direct final to an interim final. I guess this sort of relates to Ron's comments as well. What if, in fact, there are significant problems with a direct final rule? How do we deal with that? I would just note that the direct final rules are typically promulgated when notice and comment is deemed unnecessary, as opposed to an interim final rule, which typically invokes impracticability or public interest. And so they are different animals, I think, in that sense, and maybe that needs to be clarified. Thanks.
Thanks, Mark. Jeff Lubbers.
Thank you. First, I want to agree with Ron. I made this point on line 141 on my comment that I said I don't think that these outreach methods would make sense or even be worth considering for some of these good cause rules, such as most rules encompassed by the unnecessary prong. But even for the other two prongs that Mark just mentioned, I don't think the agency, in some situations, the agency wouldn't want to tip off people that they were even considering a rule. If it's unpracticable to go through notice and comment because, the government's wants to propose a moratorium on something, they don't want to talk to people about the fact that they might propose a moratorium. So, I think I agree with Ron on that point. The other point I wanted to make was we're talking about the GAO report looked at lots of rules that did not have an opportunity for public comment. And some, majority of those were because the agencies invoked the good cause exemption, but a lot of them were the agency invoked other exemptions. And so if it's within the proprietary exemption or the military and foreign affairs exemption or the procedural rule exemption, it still might be a good idea for the agency to do an interim final rulemaking in those situations. So, we're being a little under-inclusive, I think, in this recommendation by not considering other situations where the agency would have a legal reason not to go through notice and comment.
Thanks, Jeff. Andrew.
I just want to pick up on the discussion of the DFR. From sort of my understanding and hearing the stories of its inception, it was not just a situation where something was unnecessary, a minor change, but where it was unnecessary because of the lack of controversy, that the agency was doing something that they didn't think anyone would care, but because it's not controversial, but it was a substantive change to the regulations. And I think sort of the story on the creation of the example is usually with the EPA updating incorporation by reference for its state implementation plans, that the people in a given state would be required to meet the new state implementation plan put out by the state, but the agency would have referenced an older version of the plan in the regs. So the EPA inspectors would be inspecting version 7, and then the state inspectors would be enforcing version 8. And so the agency would be updating their incorporation by reference, and in a way to try and move things along more quickly, they'd call it a direct final rule, because they're saying, well, my goodness, we are certainly making a substantive change, big changes between version 7 and version 8, but it's not controversial. And they put out the direct final rule. If anyone, begs to differ, then they would withdraw it. That was the whole idea behind that. Typically, the direct final rule would have like a 30-day comment period, but it would be effective in like 45 days. So it would give some sort of a window to come in and change it. I think some of the points other people made that, with respect to something that's truly unnecessary, like a minor change, having the agency even waste the time of inviting any comments just seems to be, a bit much. But it does, I always saw the direct final rule as sort of, particularly relevant in that situation where the agency is doing something of substance.
Sorry.
Good.
Sorry, can you hear me?
Yep.
Yes.
Okay, sorry, I just lost my sound. I missed the last of your comments, Andrew, but if the rest of the committee got them, I think that's probably the most important rather than having you repeat what you had said. So I'll turn to Ron.
Yeah, I'm just responding to Andrew because having done the consultant's report on direct final rulemaking in 1995, I got a lot of background, and the state implementation plans were the original context in which it was used, and used widely and continuously and successfully for the most part. And yeah, they may not have been minor in impact, but if they expect no controversy, then the rationale for direct final rulemaking applies. We're doing it because we don't expect any controversy, but if we're wrong, let us know. If there's controversy, we'll start over. So minimal, minorness is a usual correlate with the right form. But if you don't expect controversy, then it does fit. Right. And so that should have worked in the Melise case, which I've mentioned, but they didn't, the CPSC didn't quite handle it right. But if they had followed the normal norms of direct final rulemaking, there would have been an objection. They would have had to either abandon it or use notice of comment.
Okay, so if there are no other general comments, I think we will be returning to these questions and issues that have been raised and these initial comments throughout the
Bertrell speaking. I can't hear him.
Yeah.
Yeah, Bertrell, are you still talking?
Me either.
Can you hear me now?
Yep.
Okay, sorry. There's like weird things going on with my computer. So we'll return to these general comments as we move forward. I think that, sorry, I'm looking at my chat right now. Nina, you have a comment.
Yeah, just generally, I think, I appreciate the kind of strict norms we're trying to establish here for what is a proper direct final rulemaking and what's a proper interim final rulemaking. And these are clearly useful tools, but one valuable function that this recommendation could serve would be to re-emphasize what we think are the proper norms, because I'm not at all clear, and I'm curious to know from Mark if agencies' practices in these areas are actually following the norms that ACUS had in mind in 1995, or in fact, if they are kind of mushing things together or using direct final rules, the rulemaking process perhaps inappropriately, as the CPSC did in Melise.
So I mean, I think it's one of the things that we'll have to, figure out in terms of going forward. I think the RFP was really about public engagement in agency rulemaking when the agency invokes the good cause exemption. The question that we have to answer going forward is how much these concerns about the use of DFRs and IFRs melds into it, how much we want to incorporate the guidance as recommended in the report into the discussion of the public engagement. I see them as definitely linked. Is there a way to separate them out such that we can engage with one without the other? Maybe it's not possible. Maybe we have to do both. That's one of the things that we're gonna have to figure out. Nina, you had a follow-up?
Yeah, I think the way in which agencies might be using them inappropriately has absolutely to do with whether they're engaging with public feedback or not. So, in the Melise case, they said, oh, we'll think about public comment, but that they didn't. Perhaps that was because they misidentified the rule or because they mishandled what they said mishandled the procedure they said they were going to follow. But I actually think to Ron's point, DFRs are supposed to be uncontroversial. That refers to expected public response. So I do think these two are intrinsically related.
Okay. Thank you, Nina. Thanks for your patience, Alex.
Thanks. OMB thinks that the recommendation should be clear that this is a policy recommendation and is not recommendations to mitigate agency legal risks with respect to good cause justifications. OMB notes that some of the recommendations, for example, 7, 8, and 12, may raise substantial litigation risk for agencies' good cause justifications. That risk should be considered and addressed, or those aspects of the recommendations dropped. OMB believes that the recommendations should focus on encouraging appropriately robust post-litigation public engagement by agencies on rulemakings issued under good cause and building on the recommendations of 95-4. Further, OMB has questions about the underlying authorities for recommendations 13 and 14 that would require further analysis. Obviously, we can discuss further once we get there. Reframing recommendation 13 to be directed to agencies rather than calling for an EO would probably address OMB's concerns. Finally, OMB disagrees that the requiring the sunsetting of rules under good cause after potentially arbitrary time period is appropriate. Instead, OMB suggests that the recommendation should encourage agencies to address public comments on such rules within a reasonable amount of time. Thank you.
Okay. Thank you, Alex. We'll return to, hope you will chime in when we get to those particular recommendations as well to make sure that we address the concerns that you've raised in your comments here. Daniel or Mark, do you have something that's directly responsive to Alex or?
No, go ahead with Daniel
Okay.
and I'll
Okay.
respond afterwards.
Thanks, Mark. Daniel.
Hi, there's been some discussion of the Melise case in CPSC. I was wondering what folks thought CPSC did wrong in that case.
Anybody have answers to that question directly before I turn to Mark? Ron, do you have responses to Daniel?
Yeah, what they did wrong was to assume that they had not received a significant adverse comment because they disagreed with the comment. That is grossly misinterpretation of what ACUS means by significant adverse comment. So they should have received it and say, okay, we may not agree, but it's now clear that public comment isn't unnecessary. So we'll hold a notice of comment proceeding. And in all likelihood, they would have done the same thing that they ultimately did, but they could have done that legally.
So in Melise, the law had already changed. The direct final rule was just to update the CFR to reflect what the change in the law already was. So it wasn't that CPSC disagreed with the comment, it was that it wasn't a significant adverse comment because it had nothing to do with the action that CPSC was taking.
Ron, do you want to respond to Daniel or?
Not right now.
Okay. We'll turn to Mark.
Okay, thanks, Bertrand. Couple thoughts from some of the comments that have been offered. First, regarding Nina's comment about whether agencies are making proper use of IFRs and DFRs, I would say largely yes, at least that my sense from the interviews that we did with a number of different agencies is that they more or less are using them. The bigger concern that I had, frankly, was that there often was not good follow-up. So particularly with IFRs, for example, they would just let them languish. They would not issue a final rule at some point, and I think that needs to be pinned down better. You know, and with DFRs, one of the reasons I suggested that final no comment rule, because there is this distinction, you know, if it's truly unnecessary, if it's truly trivial, as I think Ron was suggesting, then it seems to me there's no need for comment whatsoever. You don't need a direct final rule. It probably needs to be a different category. And indeed, some agencies are using what they sometimes call a direct to final rule, which struck me as just too close to DFR to be distinguished easily. But there is this other category. And of course, the whole good cause exemption suggests that you don't need to do any notice and comment. So if you're properly invoking the good cause exemption, presumably none of this is relevant. What we're doing here is suggesting that perhaps there are some reasons to offer notice and comment, even if maybe it's not technically required under the APA. I also just wanted to quickly respond to something that Jeff Lubbers said, because I agree with him, but I want to acknowledge that it was somewhat outside the scope of the project. So I have concerns about some of the provisions in 553 that allow exemptions for things like military activities or public property or loans or grants, those kinds of things. I was told that that was really outside the scope of the project, but I'm hoping to do a broader article based on the report, and I will definitely be dealing with those issues in the broader article. So thank you.
Great, Mark. And yes, I didn't respond to Jeff's point. I think that we will have to treat those outside the other exemptions outside the scope of our discussion today. But we as a committee, if we ultimately decide that they need to be in here because they're intrinsically and necessarily linked, we can have that discussion. But for purposes of our discussion today, the default and the presumption is that those other forms of exemptions will not be part of the discussion today. Ron.
Yes, so I didn't want to get ahead of our line by line discussion, but I think even though agencies have made up this category of direct to final rulemaking, there's no reason for it to exist. Those are ones that should be handled through the direct final rulemaking process under the unnecessary exemption. That's exactly what they're for. If you understand the definition of unnecessary as the case law defines it, they are for minor technical rules. And so distinguishing between really technical and rather technical, I think is a losing game. I don't think we need to invent a whole new, they should have invented a whole new category. With regard to the other point that was just raised, 95.4 does say agencies should consider using post-promulgation comment procedures for all rules that are issued without pre-promulgation notice of comment, including interpretive rules, procedural rules, grants, contracts, military, etc. So we've already crossed that threshold in the previous recommendation. Footnote, this doesn't apply to unnecessary. This only applies to impractical and contrary to public interest.
Okay. I appreciate that, Ron. Miriam.
So with respect to the direct final versus a direct to final versus whatever, if an agency is truly making a non-substantive change and is using a good cause exemption, they can do a final rule. They can do a final rule with comment. They can do a technical amendment. So if they're updating addresses because they moved, that's a technical amendment. There's no need for, there's no need for public comment on that because it's a done deal. They just have a new address. But I wouldn't suggest that any of those non-substantive changes go through a direct final rule because it can just be straight to final, but it's just, that's a final rule. The Administrative Committee of the Federal Register did a final rule with request for comment 2 years ago, I believe, after discussions with the ACFR DOJ member. We anticipated getting comment. We did not anticipate any of the comments actually having an impact on what we did. We will be following up those comments that we received after we made the changes. The changes we made were with respect to eliminating microfiche as an official format of the Federal Register. We didn't have anybody who could actually make the microfiche anymore, basically. And you can't, there's nobody around to actually repair microfiche machines. So we still got comment on that. But there's no way that we can keep microfiche as a legitimate official format because the technology is obsolete and there's nobody around who can actually create microfiche. So we got comments. We will be dealing with those comments in another final rule that will be coming out at some point. But doing that as a direct final rule wouldn't have made any sense. The direct final rule is when an agency, or one of the uses would be an agency believes something is non-controversial. We've talked about the EPA SIPs. EPA does get substantive comment every once in a while, which shows that they did actually need to get comment on that. that they needed to deal with the comments. So then they withdraw the direct final rule. And then they rely on the proposed rule that they already published, fold those comments in there, and then they issue another final rule. Most of the time it doesn't happen. That's because agencies are going to use it for when they believe there is no controversy, but there could be controversy. So it's not just that you either do a direct final rule or you go through notice and comment.
Thanks. Thank you, Miriam. We have a couple more folks. I want to make sure that we get to the actual recommendations, a line by line assessment. So I hope that we can limit it to just general overall comments. We will discuss direct final rulemaking. We'll discuss interim final rulemaking, and we'll try to sort of sort out the distinction between them for the purposes of public engagement. But I'm going to try to move us forward, allow Bill and Annalise to say something, hopefully that they're about the broader recommendations before we kind of dive in line by line. Bill.
Thank you, Virgil. I want to make a statement in favor of going beyond pure public participation and going to best practices, which is what the title of the report is. But I also wanted to say again about temporary regulations, all right, which is the Coast Guard and the FAA issue tons of direct to final, or that is, there's no delayed effective date for these things. They're emergencies in the sense that they're time sensitive. They have to be done right away, but they also have a deadline that's, I mean, they're temporary. They're usually in effect for a couple of weeks, if that long. And the point is that that concept of a temporary regulation without any comment before or after is something that seems to be completely missing from the recommendation. And I think that's very important that we keep that in mind.
Thank you, Bill. Annalise.
Thank you. Hi, Annalise Marchessault with the Department of Transportation. And I just wanted to add, I know we wanted to get to the recommendations, but regarding the discussion of final rules without notice and comment, the way that we typically refer to direct to final rules, as you're using that term, I do think that there is a use for them. At the Department of Transportation, we use them for such things as statutory changes in which there's no discretion. And, you know, for example, a definition has been changed statutorily and we're updating the regulations to conform to that. We don't really see value in using government resources and seeking public comment on something that, you know, can't be amended in any way. So for instances like that, a direct final rule isn't really going to provide much value for either party. We also have used it for instances when we've used, contrary to the public interest, for temporary flight restrictions. Those are typically based on confidential information, and the public can't really weigh in meaningfully on them. And even to the extent that the public did comment, we probably would not be able to take their comments meaningfully into account because they wouldn't have the full information that the government has to make those kind of assessments. And those, to Bill's point, those are typically temporary. So just wanted to add that context.
Okay. Thank you, Annalise. I didn't desire more hands to go up, but they have gone up nonetheless. Andrew and Jeff, again, we're focusing on general overview comments and we will get to specific recommendations going forward. Yes, Andrew.
All right. Yeah. Sorry to undermine your mission. But the interim final rule, I think, is a sort of a poor choice of words. As I understand it, the creation of it was originally, the original phrasing was sort of just a final rule with request for comments, because that's essentially what it is, a final rule, and it's requesting comments. And that's how it was, I believe, first used by the FAA many years ago. Other agencies saw it as a good idea, and it's basically the agencies in some level doing a CYA that, hey, we are doing something that we think is an emergency, and so we're having to act quickly because it's an emergency. We have good cause argument of impractical and perhaps a little bit of contrary to public interest. But, you know, when it's an emergency, you might miss something. So they put out a request for comment. So they say, hey, here's it going to be effective, maybe immediately, maybe in 30 days. But we are inviting comments because we might have missed something and we might do a follow-up document to change it. Other agencies, as I understood it, sort of copied the idea, and then the sort of the telephone game, the title morphed into being called an interim final rule. I think interim is sort of a poor choice because I think actually the word interim is a synonym for temporary, and interim final rules don't necessarily mean they're temporary at all. I mean, they could be indefinite. So I think part of the problem is just with the word interim causes some confusion. But that's, as I understand it, the FAA still uses the phrase final rule with request for comments when they're doing what other agencies would call an interim final rule. And I think it's a more straightforward phrasing.
Yeah, this mind-spinning discussions on different definitions and evolutions of these terms is, I guess, reinforcing the point that Mark was making about the importance of definitions and maybe the value of including such definitions in these recommendations. But Jeff.
Yeah, I'm going to make a comment that when I was a staff member at ACUS, I didn't like to hear, which is that I'm wondering whether this recommendation really adds value to recommendation 95-4. The main difference between the two is that this one focuses on public engagement. Of course, the ACUS already has a general recommendation on public engagement and rulemaking, which is very good. So do we really need to have a special recommendation on public engagement in what's called good cause rulemaking? 95-4 talked about it in terms of non-controversial rulemaking, which by that they meant direct final rulemaking, and expedited rulemaking, and post-promulgation comments. So I'm going to reserve judgment, but especially after hearing the comments of the OMB representative and some of the others, if those parts get stripped out, I'm not sure what we're doing differently from 95-4 in a way that would add value. So I think this is something we need to sort of consider throughout the discussion of this recommendation, whether it's really an improvement on 95-4.
I completely agree, Jeff, and I appreciate that point. And I hope it's something that we all keep in mind with reference to 95-4. We don't have a, Ben, you don't by chance have a link to 95-4 that you could put into the comment thread so that people have access to that they can read?
Yep, yeah, we can drop it in the chat. Thanks.
I can do it. I've got it right here.
Okay, thank you so much. I appreciate it. So that people, not necessarily during the meeting because it's hard to read and do this work, but maybe after the meeting, it could be something that people could take a look at and we can discuss further as to the continued utility of the recommendations here in light of what we understand with respect to 95.
And one more quick point. I think it might make sense to have to consider a recommendation, a separate recommendation on temporary regulations, because that's something we really haven't propounded on.
Okay. So without further ado, with all of these general comments in mind, and I think that they'll be re-raised, of course, during the process of discussing each of these recommendations or discussing the recommendations one by one. We'll proceed as we normally do. What we'll do for purposes of time and allowing us to focus is, to the extent that we are seeking modifications to the recommendations that are put forth here, and it's not necessarily that you have specific wording, but if we could capture kind of the spirit of what you want in terms of the change, and then we'll go back to the drawing board with ACUS staff to make the changes that we think we heard, and then we'll return to those changes in the second meeting. I think that will help us be more efficient with respect to our time and avoid the challenges that are associated with wordsmithing on the spot. So I hope that is not objectionable. If anyone has objections to that approach, please let me know. If not, we'll proceed with recommendation number 1. And as I've always done, we'll give you a chance to read recommendation 1. I think we'll just do what's on the page. 1 I guess we'll just start 1 and A, and then we'll go 1 and B, and then we'll move on to the next page to discuss C going forward. So let's start with 1. Yes, Ron.
Yes. Am I on video or not, or audio? You can hear me?
You are on video and audio, yes.
Okay, so I'm gonna channel Michael Hertz because he's not here. But what he said in his comment is one I agree with. If the agency believes that public comment is impracticable or contrary to the public interest or unnecessary, it should not do notice and comment, period. That seems to me completely clear from the definition. And so paragraph 1A is mistaken. I think that's what Michael was saying. I think that's right.
Yeah, I believe that's what he's saying as well. So what you would propose is to delete A.
Yes.
Okay. So Ron has proposed deleting A. Is there folks who object to that deletion, who think that there is a purpose served by A? Give folks a chance to read and reflect for 15 seconds. Okay, Nina.
Yeah, I definitely agree with the deletion. I think based on the conversation we've already had, the critical point is to advise agencies how to responsibly handle comment that they do receive after they've issued an interim final rule or direct final rule.
Thank you, Nina. Andrew.
The only point I was going to make is, and I can't remember where I saw it in here, but I saw something that said that the APA sets up, I thought I saw it as a minimum end, like a ceiling, which I think I can't remember where I saw that, but it said that the APA sets up minimum and a ceiling requirements, which I'm not sure that was in the report.
Some of that language is in the report itself, in Mark's report.
Okay, yeah, well, that I thought was just I didn't agree with it. I mean, I'm not aware that the APA sets up ceilings. But with this sort of point, the APA does set up minimums, and if an agency does want to invite comments, even though they're doing something and fall under good cause. I mean, there are lots of exceptions that agencies can use, but it's not always the best judgment to claim an exception. There are quite a number of exceptions. And agencies can make an argument for an exception, but they can also choose to say, well, even though I could make an argument, I'm going to go through notice and comment because there could be some value there. And I think with the good cause exceptions, that's true as well, that they might have a good cause argument, but they might decide that there's some value in inviting comments.
Yeah, and I think that was kind of the spirit of A is yes, good cause. You know, the agency could invoke good cause, right? And there could be good cause, but A is nonetheless seeking to encourage the agency to proceed with notice of comment procedures if it is nonetheless appropriate and feasible in light of their capability and authority to invoke good cause. I think that's what A is getting at, but it's not necessarily mean that we should keep it. You know, if the committee sees it appropriate to delete it, we will proceed in that way. Jeff. You're mute, Jeff.
Maybe if we added the word nonetheless, it might help. But I think under the other exemptions, we often say that the agency should, voluntarily not invoke those other exemptions and go through notice and comment. This may be different because if it's impracticable or contrary to public interest, then they probably shouldn't. But so I don't want to be anti-agencies, going through notice and comment when they don't have to in every situation. But if this is different, and maybe we should say it's different somewhere.
Right. Okay. Thanks, Jeff. Bill.
The idea that an agency might use either interim final rulemaking or go through a whole notice and comment rulemaking to avoid a litigation risk because it might be questionable whether they really do have good cause. that's an interesting idea that maybe we should take into account. But here it says when the agency finds it's inapplicable and unnecessary, and it's that finding, all right, that once they found that, they should I with Ron and Michael Hertz, they shouldn't be engaging in notice and comment rulemaking because they shouldn't. It's if there's a question about it. Now, if you want to rephrase it, all right, so that when there's a question, they might do this stuff. Then I can see a place for it.
Right. Yeah, I appreciate that, Bill. Yeah. So okay, I hear that point. Emily.
So I guess my question is whether the purpose of this provision is to sort of affirm a principle that agencies that the default should be notice and comment. There's a line to that effect on page 29 of the report. And certainly a lot of ACUS's past recommendations have been in the vein of sort of notice and comment should be the default and exceptions should be used rarely and minimized. So I wonder if that sentiment, if indeed that's the sentiment that this is supposed to be expressing, could be better made if it were broken out, not as something under good cause rulemaking generally, but as a sort of more fundamental principle of, the default should be notice and comment, and that's the principle that is going to govern sort of the rest of the recommendation about how agencies should engage in these various types of rulemaking.
Right. And so that could be potentially incorporated either in the preamble or in the lead up to recommendation 1 or as part of recommendation.
Yeah, I mean, I think I would envision it as recommendation 1 as sort of a statement of principle that it would be, I think, a reflection of prior recommendations. I mean, you could put it in the preamble, but I think it might, and if it doesn't have a should in it, it shouldn't be a recommendation. I know. But so you could but I think you could find an appropriate formulation where it might have more impact and stand out quite a bit more as a recommendation 1 that sort of sets the foundation.
Right. The default should be notice and comment rulemaking, but if the agency finds for good cause, something along those lines. Ron.
So I think there has been mention of fleshing out the preamble, and I think what you might want to say is, in the case of several of the exemptions, grants, contracts, military affairs and the like, agencies should consider using notice and comment anyway. And indeed, ACUS has called for the repeal of those or the modification of those. We're certainly on that page. But good cause is different. If the agency finds that it's impractical, contrary to public interest, or unnecessary, it should not do it. Period. To apply the narrow and interpretive construction policy over there is simply not to analyze it closely enough to see that this is a different case. Now, I agree with Bill. Conceptually, you could say that if it's arguable, then maybe you should lean in favor of notice and comment. I can see that, and sort of Andrew's point also. And that would be possible to say, but I think really it doesn't belong in paragraph 1. The paragraph 1 is designed to be a lead-in to the further recommendations that talk about how to deal with the situation where you've already decided that notice and comment is impractical, et cetera, unnecessary, contrary to public interest. So it is not logical to begin this by saying, well, maybe you don't need to do it at all. That's the work of the preamble, but the point here is to talk about what you should do when you've made that threshold determination. And so I think 1A should just be deleted.
Okay. Thank you, Ron. Jeff.
Yeah, I think we could handle some of this in the preamble, especially making the point that courts construe the good cause exemption narrowly, so that relates to the litigation risk. But I also want to point out that ACUS recommendation 92.1 on the procedural rule exemption, which was based on a report that I co-wrote, begins with the first recommendation is federal agencies should exercise restraint in invoking the APA's statutory exemptions to the notice and comment rulemaking procedures. Thus, the Administrative Conference has consistently urged agencies voluntarily to use notice and comment procedures when issuing rules that fall within the terms of most of the exemptions under Section 553. And then there's a footnote that mentions some of the earlier recommendations that suggested getting rid of some of these. So, AICS is on record as generally having this principle. And I think it's a good principle, although I think we need to differentiate it here.
Right. Thanks, Jeff. It's nice to have that institutional memory. Paul.
Yeah, so I just want to say, I think that some of the difficulty here is caused by the fact that 1A touches on two distinct points. One is is an agency's conclusion that in fact it would be contrary to the public interest or unnecessary or impracticable to do notice and comment, right? So surely if an agency decides in the exercise of its judgment that it would be bad for the interest of the country to do notice and comment, well, then they shouldn't do notice and comment. But they also might find that they're entitled to the exemption under the standard articulated by the courts. But in fact, actually everything would be just fine if they did notice and comment. The standard articulated by the courts has some play in the joints. I think we all know that. And so it may be that in the agency's best assessment, though they qualify for one of the exemptions, they actually could conduct notice and comment. And so I think it's important to change the focus of the comment to or of 1A, and probably, by the way, this involves moving 1A to focus on the legal standard. Yes, surely if the agency concludes that in fact it's contrary to notice and comment is contrary to the public interest, we wouldn't want to advise them to proceed with it nevertheless. But most of the comments that folks are making now are about what the agency should do, even though it might, to take notice and comment, even though an exemption might be available to it under the legal standard.
Right. Thanks, Paul. Nina.
So I just wanted to ally myself with Emily's comment that I think it would be a great idea to include a paragraph 1 that basically states, basically, except if it's clear, there should be notice and comment rulemaking. I see this recommendation as responding to a few things. One is courts might be construing the good cause exception narrowly, except maybe in Little Sisters, not so much. Maybe the courts are going to end up being quite generous on the extent to which agencies can use ex post comment rather than going through what we see as kind of the conventional notice and comment process. The second point is that, AICS in the last 5 years has issued 3 recommendations at least, encouraging agencies to do public engagement in rulemaking, plus our recommendations on guidance documents, which also encourage public engagement beyond what's technically necessary. I think this recommendation could be consistent with those. The practical problems here are, first, agencies might have a close call to make, so we want to guide them in invoking the good cause exception, when it's appropriate. And once it's appropriate, then yeah, logically they should skip notice and comment, but there might be a close call and this recommendation could offer useful guidance. And then ex post, if they go through and invoke the good cause exception, responsibly handling adverse comments in case they did get it wrong. And in fact, the rule was not uncontroversial. So I think it's consistent with our recommendations in the last several years on public engagement to include a statement like that, and then to properly guide agencies on when exactly they ought to be invoking these exceptions and how they should handle comments that come in later.
Right. And Nina, I'm hearing you say, consistent with Emily, that statement should be within recommendation 1 rather than, and perhaps a preamble, but also within recommendation 1.
Yeah, I mean, that said, I don't have specific language to propose, although
yeah, that's okay. Yeah, we'll work on that.
Right.
Yeah. Okay. So we have sort of instructions, and what we'll do is come back to the committee with proposed language that we will incorporate in 1 and see how that fits, and then maybe do the wordsmithing, see if there's agreement on that language. But that doesn't change your view that A should be deleted. Is that correct? Okay. All right. So we have Ron's proposal that we delete A, in light of Emily and Nina's point that maybe we want to make a statement about encouraging and referencing and defaulting to notice and comment. Any objections to deleting A? Okay, we will delete A and seek to add some language between now and the next meeting, consistent with Emily and Nina's comments. Okay, so to 1B. I think we'll have to scoon, yeah, scoon, yeah. There. Oh, I guess that's it. 1B. Oh, yes, yeah. Sorry, I thought it went down further. So 1B. Okay. Bill.
Well, I have a problem with B as well. First of all, the reference to paragraph 8, interim final rulemaking. When I look at paragraph 8, I don't see anything relevant to interim final rulemaking, but it says here using alternative rulemaking procedures, including direct final rulemaking, interim final rulemaking. And the question is, what else is there besides those two? If it says, is there something in addition to direct final rulemaking, interim final rulemaking, which would be what's suggested by saying including? And I would say that at least one area, temporary rules, would be something that might not come under either direct final rulemaking as we've defined it, or interim final rulemaking as I don't think we've defined it. So I have problems with this particular subsection B here.
And so, Bill, the and is linked to C, to other forms of public engagement.
I don't know if other forms of public engagement are alternative rulemaking procedures.
Got it. Okay. So would a revision to say using alternative rulemaking procedures to adopt final rules, including direct final rulemaking and interim final rulemaking, full stop, would that address your concern?
No, because it would not identify what other alternative rulemaking procedures there might be. And as I said, temporary rulemaking, temporary rules, which don't fall under our definition of direct final rulemaking or interim final rulemaking.
Okay. And so you would
negotiated rulemaking.
Okay, but if they've found that notice and comment rulemaking is impractical, unnecessary, or contrary to public interest, I don't think negotiated rulemaking is an alternative.
Ron?
So I pointed this out in the comments, but 95.4 did specifically say our recommendation for post-promulgation comments solicitation does not apply to temporary rules, which are going to expire within a few weeks, so it'd be silly to do it. So I don't think there's a different disagreement about substance. It seems to me probably one is not the place to get into that level of detail. But what you do is take the word other out. Given the preamble to one, what we now call B will become A, should say is alternate rulemaking procedures, including direct final rulemaking and interim final rulemaking, period. Or if you don't like including, you can take that word out too. Because what we're saying is, if you find that the good cause exemption applies, then consider using the two main types. Something like that.
Yeah, so consider using direct final rulemaking or interim final rulemaking.
I could live with that.
Yeah, as appropriate.
As appropriate.
Although, I mean, Ron, don't we need to address temporary rules somewhere?
Yes, just not not in the introduction.
Okay, so those are the proposed changes. Miriam.
So I just want to make a comment about temporary rules in general. They can be used as an alternative. they do not have to be used as an alternative. An agency can in fact get notice and comment on what they're suggesting as a temporary rule. Whether we want to recommend that temporary rules be temporary and less than a year, and if they're not, then they shouldn't be temporary. That's a completely different discussion. But right now, if the rule is set to expire and it's within the scope of the administration, an agency can have a temporary rule that is more than a year. And depending on what they're doing, they can actually propose the temporary rule. So they would go through notice and comment on the temporary rule. So if we want to deal with temporary rules, which I think is a good idea, I think we need to then be very specific about what it is that we are defining when we talk about temporary rules.
Yeah. I mean, this kind of goes back to Mark's point in terms of the importance of definitions. And I don't know in terms of.
Bertrand, can I just respond quickly to
Yes, please, Bill.
that thing? If the going in thing is the good cause exemption applies, because it's an emergency usually, right? Then notice and comment for a temporary rule wouldn't be appropriate. But Millicent is clearly correct that there are situations where you have lots of lead time before the temporary rule would go in effect, and so the good cause exception simply wouldn't apply in the first place. So we're only talking in this recommendation about temporary rules that qualify for the good cause exemption anyway.
Okay. Miriam, do you have any response that you want to make? Or
No, that's fine. I just want to be clear that we're not talking about all temporary rules in the same way that we are talking about direct final rules.
Okay. Thanks, Miriam. And thanks, Bill. Jeff.
I mean,
I don't
one
know if you guys are hearing
alternative.
a buzz. Is that my computer? Are you guys hearing a buzz as well?
Yeah.
Okay.
One alternative would be just a shortened comment period. If we're talking about a temporary rule or an emergency rule, it's still the agency could give the public 10 days or 15 days to comment. That's a possibility in some of these situations.
Okay. I mean, so I guess we'll hopefully get to a point where we're thinking about where temporary rules might fit in. I think we're going to need to reflect on what a temporary rule is, what makes it temporary. I don't know in terms of how well that fits within this proposal. Let's focus on public engagement, but we should address that when appropriate. Turning to 1B. So one change that we did make is instead of beginning B with using, we've moved to consider using. Are people comfortable, or members of the committee comfortable with that change? Because we'd also have to change 1C to consider using as well. If there are no objections to consider using, I just recommend that we add consider using to 1C as well. All right, so with 1B, are there any objections to the changes that were proposed? By a combination of Ron and Bill, I believe. Okay. We'll incorporate those changes. And 1C, I would propose the change to the beginning of to consider using. And then I'll give you guys a chance to read the rest of 1C and see if there are any comments. Okay, Ron?
Yeah, I think this is again channeling Michael, but I would limit C to where the agency believes that notice and comment is impracticable or contrary to the public interest. It should not apply if they think it's unnecessary.
So
What sense would it make to say that notice and comment isn't necessary, but outreach to individuals and meeting would be desirable?
Right.
That would be dumb.
Right. So consider using other forms of public engagement to supplement the rulemaking process. And would you, when notice and comment is considered found unnecessary and contrary to public interest, or how would you sort of word
Yeah,
that?
that's
How about starting C with?
yeah.
And
In the case of rules that the agency finds or cases where it finds it would be impractical or in public interest, comma using.
Okay.
consider using.
Consider using.
Okay. Okay. Right. Thanks, Ron. Alex.
Similar to my general comment, it should be clear that this is a policy recommendation and not a legal recommendation to mitigate risk. The recommendation could be read as implying or suggesting, obviously this is not the intention, that these other forms of public engagement would somehow be legally adequate substitute for the notice and comment process. So suggest adding some language, and unfortunately I don't have specific language to propose, just to be clear that this is not a legal substitute for the notice and comment process.
Okay. So why don't we, Ben, unless people have specific language that's responsive to Alex's suggestion, why don't we kind of bring that to staff to figure out what language to use to make it clear that it's a policy matter?
Yeah, I'm making a note on the side, but I can make a comment in the document itself. I mean, is the basic idea that we want to make clear up in recommendation 1 at the outset that these are not addressing legal obligations on the part of agencies, they're addressing best practices.
Alex, would that be responsive in terms of addressing your litigation risk comments throughout the document, saying something up front in that way?
Yes, I think so. Yep. Thank you.
Okay. We will work on putting that language together. Okay, Jeff?
One little style thing you could avoid saying consider in both B and A and B now by putting it up in the number 1. The agency should consider engaging with the public as follows, or something like
Okay.
that.
Yeah.
That's just a thought. I also made a comment about the word should. I don't know if you wanted me to bring that up now or.
Yeah. If it's yes, sorry. Pull up the comments again. Yes, please do bring it up now.
So I'm just not sure should's the right word there, because should the agencies should consider seeking targeted outreach to individuals who should participate in the process. I mean, who might be interested in participating in the process, or you don't want to have the agencies try to figure out who should participate.
Right.
So,
right. I think that's right. That makes sense to me. Who might be interested in participating, who
might be stakeholders. I mean, or whatever.
Yeah. Okay.
May wish to.
May wish to, may desire to.
Yeah, may wish to. Yeah.
Might be expected to.
Expected to. Okay.
Yeah, I'm just dropping Jeff's language from his comment, which is to the
Got
right.
it.
But we can
Okay.
do other language too, just let me know.
Sure. Thanks, Ben. Okay, Bill, and we'll kind of return to the overall language of the comment shortly. Bill?
Yeah, I wanted to vote in favor of deleting to supplement the rulemaking process, as well as the person who comment. I don't remember who made that comment, but I agree with the comment because I don't think we need to say it. And it just, when you say supplement, I almost immediately think supplement the record. And I don't think that's what we're involved in there.
Okay.
So I just don't think it adds anything. It might confuse issues. And then I'd like, this is for Miriam, the question of, she objected to using the word notices, if I recall correctly, because she asked whether or not, she suggested this wouldn't qualify for the notice section of the Federal Register. And I didn't, when I read it, I didn't think this was saying it would necessarily go in the notice section, but where would a request go in the Federal Register? I mean, if not as a note in the notice section. I mean, it's not part of a proposed rule. It's not part of an actual rule. It's not presidential. There's only one place left, right?
Before we turn to Miriam, why don't we just sort of make sure we put the proposed deletion to supplement the rulemaking process in there, and then we could sort of decide on whether we want to do that. Miriam.
So it depends on how the RFI is drafted. If it is drafted in such a way that it makes clear the request is for the purpose of making a regulatory change or evaluating whether or not to make a regulatory change, then under 1 CFR 5.9C, I think it's B or C, I always get them backwards, then it is directly related to rulemaking. It is still a proposal in that sense, because it is, it's not a final agency action. So those then would publish in the proposed rules category of the Federal Register. If it is drafted in such a way that it does not directly suggest that an outcome of getting the information would be regulatory, then it would publish in the notices category. Unless the agency puts a CFR citation in the heading, in which case it would go in the proposed rules category. So, I mean, so it's not that it wouldn't publish, but it would not necessarily publish. It depends a lot on how the agency drafts them. The problem I have with using notice just in general to refer to a document in what we put out is that not all agencies, but a number of agencies will invariably point to something and say, look, that said notice. So what we're giving you is a notice, has to publish in the notices category. And it doesn't matter what your regulations are or how you're classifying the document. This other thing says we can publish a notice, so it's automatically a notice category document. So I just wanted to be clear here that we are not saying, we are not recommending a specific category for this document.
Okay, let me, then I'd recommend saying from the public through a request published in the Federal Register, just say a request published. Then I'm happy.
Okay.
And there are a number of places throughout, I did not mark them all, but there are a number of places throughout where we use notice to reference either a notification type document or just a general Federal Register document. So that my comment applies to that. Either we need to be very careful when we use the word notice throughout the whole recommendation, or we use the word notice, but we add a footnote or another type of clarification to indicate that we're not suggesting a specific document category.
Right. And so with a reference to notification, I mean, we'll come to the other parts where you use notice to see if it's pertinent. Would a reference to notification raise the same confusion, Miriam, as well?
Not for purposes of classification.
Okay. Okay, so let's keep our eyes out for the use of the term notice and see what substitute terms we may be able to use if we think a substitute term is appropriate in those instances. Thank you, Miriam and Bill. Amy.
You could also use the term announcement or document.
Okay.
That wasn't my comment, though. I raised my hand to suggest getting rid of in that line 86, different types of. So where it says and holding different types of meetings, my first question there was, what types are you referring to? So maybe just holding meetings and not different types of.
Okay. So let's think about deleting different types of there. Okay. Okay. Mark.
Yeah, thanks. So I kind of hate to bring this up at this late stage, but subpart C looks somewhat redundant with number 2, which we're getting to next. And I'm wondering whether we need to think about that. And I have some concern with respect to the language we've added about meeting with people who might be interested in participating in the process. I'm worried about rent-seeking behavior, that we're basically encouraging agencies to engage with more concentrated interests that might be promoting their own sort of position on some of these issues. And in number 2, we specifically call out the need to engage with underrepresented people, and that seems inconsistent with reaching out to people who might be interested. So I don't know, it seems like we should reconcile C with number 2, and I'm not sure we need both of them, but I guess I'd like to sort of think about how this works. And I feel like we should also make it clear that the agency needs to sort of meet in some kind of equitable fashion with different people, and that we not encourage people who just have a loud voice and want their views sort of more strongly considered.
Yeah. Thanks for that point, Mark. Yeah, I do recognize that there is maybe some redundancy here. One idea would be to say, keep the initial language in C in the case of rules the agency finds the notice of comment rulemaking would be impracticable or contrary to the public interest. Consider engaging proactively with a wide range of persons interested in or affected by the rulemakings, including regulated entities, et cetera, et cetera. I don't know if we're missing something there. There is the point of seeking public input from I think that the point of C is perhaps to reach more broadly than 2 does.
Yeah, so just to jump in real quick, recommendation 1 is dealing with kind of different forms of public engagement. Recommendation 2 is dealing with the persons with whom to engage, which is a distinction that we make in our statement of principles and prior ACUS recommendation. So that's the distinction. Just wanted to note that.
Got it. Thank you, Ben. So in light of that distinction that Ben describes, I'll give you all a chance to read it and assess whether we still think that 1C and 2 are redundant and should be
I just would note that C does really refer to reaching out and have targeted outreach to individuals. So it really does talk about who you're participating with, from my perspective.
Yeah. Okay. Bill?
Well, I was going to move on and say that with, I mean, it's still in C, but I mean, to deal with that issue, what we've been discussing, we could just end the sentence with consider using other forms of public engagement, period.
Okay.
Right. And then we have a section that talks about, what other forms of public engagement might be. I'm agnostic as to that. But but in terms of the language we have in C now, I'd like to take out affected interests and other. In other words, interested persons. And if they're not interested, I mean, in terms of Mark, I mean, interested would include people who would have an interest, even if they don't know they have an interest, in my view. And I'd also say, I'd instead of saying and holding with, I'd say or.
Okay.
I mean, this is considered doing any one of these things. It's an and or issue, but it's not like you have to shouldn't consider this as a group. It's alternative things, I think.
So the proposal is to change and to or, and then to say holding meetings with interested persons. So taking out with affected interests and other interested.
Leave it
But
interested persons.
Keep interested persons and keep with interested persons. Yeah. There. Perfect. Okay. So we have a lot of sort of changes to see on the table. And we also have the question that Mark raises as to how much we need of C given that we have in 2, in light of Ben's explanation of the function of C, different function of C in 2.
And you could have the C paragraph 7 just after using other forms of public engagement. And if because 7 goes into some detail.
Right. Okay. That's a good point. Emily.
I think Ben just put in the chat what I was going to reference, which is the earlier recommendation from, I think, 2018 on public engagement and rulemaking. And if we're just going to encourage public engagement and rulemaking, maybe we can just gesture to that recommendation and then not worry about replicating the effort here.
Good. Okay. So we could have considering using other forms of public engagement. We could full stop there, or see paragraph 7 full stop. And then we could have a footnote referencing public engagement, the prior public engagement rulemaking report or recommendations. So that could be a way to shorten things up. Any objections? I don't want people to feel like they've lost something that they value. If you have babies in C that you want to keep, speak now. A lot of these are, again, referenced in the report, but I just want to make sure there's no objections to essentially deleting everything after public engagement and putting in C paragraph 7 and then using a footnote to refer to the prior report. Matthew.
Thanks, Bertrand. Typically, we frown on footnotes in the recommendation portion of the thing. It's not that you can't do it, but it would be an exception to our normal behavior. I think you would probably prefer to put it in the text or not include it if not needed.
Got it. Okay, so we would incorporate it into the text rather than using footnote. Okay.
So, Bertrand, just to clarify, did you want to put on the table?
Yeah, I want to put on, let's put that on the table in terms of deleting everything after public engagement, putting C paragraph 7 after public engagement, and then full stop there. And then the in-text reference, and we can in-text reference to the prior report. Is that right? Yeah, so we'll just in-text reference the prior report. Okay. So any objections to that change? Okay. We'll kind of have that as our change for now. Of course, we could return to that during our second meeting and third meeting. Let's turn to paragraph 2 or recommendation 2. Give you a chance to read it and then we'll engage in comments.
And just to note, it's consistent with what Emily said previously, a lot of this language is drawn from our previous public engagement recommendation, which I dropped in the chat feature.
Thanks, Ben. Okay, Bill?
Well, I think in light of what we've done in the previous paragraph, especially noting prior ACUS recommendation. I think we ought to just drop the whole number 2.
So delete number 2 entirely is the proposal. Objections to Bill's proposal?
Does the previous recommendation make clear the need to engage with underrepresented people?
Yes.
I believe it does, yes. Any objections? Okay. We will sort of accept those changes. Okay, moving on to now recommendation 2. That used to be recommendation 3. Yes, Emily.
This is not a comment on this recommendation. I just have a question. I thought I heard early on in our discussion some objections to the idea of OMB offering guidance on this. And I think Jeff said something to the effect of, if we're not including that, then is this recommendation doing enough over our 1995 recommendation to warrant issuing it? And given that we're getting close to the end of the meeting, I wonder if it might be worth engaging that, what feels like to me a really big issue, which doesn't come until like recommendation 13. I mean, it's totally up to you. It's just a suggestion.
Yeah, I've kind of accepted the fact that we're not going to get through all the recommendations today, and we'll probably have to engage recommendations at our next meeting. I'm wary of skipping around to future recommendations for fear of losing track of where we are, and to the extent that one recommendation is linked to recommendations that follow, it may create some confusion. So that's my thoughts. Happy to hear objections or alternative preferences. I do think that we need to, engage in those prior ACUS reports to decide, whether what we're doing here is a necessary endeavor, for sure. And in light of that, answer that question at our beginning of our next meeting, we might decide that much of it is unnecessary or necessary, and we may focus on the things that we do think that this report adds, which could begin with recommendation 13. But let me stop talking and hear what others have to say. Alex.
So I had a comment on current number 2 rather than a response to the previous comment, so I can hold my hand for now.
Okay, that sounds good. Are there any sort of responses to Emily's suggestion? I guess I don't know how to differentiate between different hands raised. So I'll just go in order. Miriam.
I mean, I think if the question is open for why are we doing this and whether we should be doing this, I think we should address that question before we get all the way through and say, oh, we've now just spent 2 days doing line by line edits for something that we're going to throw out the window.
That's fair. I guess, sorry.
I mean, and speaking to that point, I think there is some benefit to this, given the questions that we get from agencies on whether and how to do direct final rules and interim rules, and whether or not they really have to do, a final rule adopting the interim final rule. That I don't think are completely addressed in the 94 recommendation. So for me, it would be of benefit to then be able to give to agencies that ask questions that I cannot answer for them because it is their internal agency decision. But I don't know for everyone else if there's enough, if that's enough of a reason to continue.
Okay. Thanks, Miriam. Having heard that point, and reflecting a bit more on Emily's point, it may make sense for us to kind of work through 95.4 and return to at least the recommendations that we think might overlap with 95.4 and see whether it's necessary. And if that's the case, we could move on to those recommendations that are in here that clearly do not overlap with 95.4. Is an idea that's drawing from Emily's suggestion. Mark.
Yeah, so I just want to second Emily's suggestion about, and I think this involves moving number 13 up maybe to the top. It seems to me logically, if we're talking about government-wide guidance on how the good cause exemption should be used, that should be upfront. I know that the current proposed recommendation doesn't include definitions specifically, but if there's support for including definitions, it seems to me that's the sort of first thing you would do in some government-wide guidance if you had it. So I think it's worth talking about that, and that is, I think, distinct from 95.4. Maybe that's all that, there are other things obviously that are somewhat duplicative, but those are, I would argue, new recommendations that might warrant the recommendations from the committee. So thanks.
Thanks, Mark. Bill.
Well, I think there's some new stuff in here that's important, including questions about number 13. But I think, again, best practices, we flesh out some best practices that are recommended here that I don't think are 95.4. So I mean, it's off the top of my head, it doesn't look to me like we're not doing something worthwhile.
Okay. And that includes items before recommendation 13 as well,
Yes.
Bill?
Yes.
Okay. Great. Thank you. Jeff.
I guess I'm not totally convinced of that yet, but as for number 13, I just wanted to say that I don't see any problem with ACUS issuing a recommendation to the president as to what kind of an executive order, to make an executive order. I do question whether we should have a parenthetical in 13 about not including independent regulatory agencies, because ACUS has already basically said that these kinds of rulemaking executive orders should apply in principle to independent agencies already. But, you know, as a matter of statutory authority, of course, Administrative Conference can make recommendations to the White House. So I don't see a problem with doing it in principle.
So if there are no objections, what I suggest is that we kind of move down to 13 so it's all visible to us, and we can sort of have that conversation. I do want to be mindful of not spending valuable time, well, new recommendation 12, not spending valuable time on something that we deem unnecessary in the second meeting. But I don't want to preempt Ron. Ron, do you have something to say about something above before? And then
I was just going to echo Miriam that if I'm not on the committee, but if the committee's will is not to pursue this recommendation, then we don't need a second or third meeting. So that question is right, but I don't have an answer to how it should be answered.
Yeah. Yeah, I agree. I think we would need to at least have a discussion as to whether 95.4 captures, you know, what we're trying to recommend to agencies in current recommendations 1 through 11. It could be a very brief second meeting if we say, yes, we don't really need this, but at least I think it would be valuable to have that discussion. Okay. Well, let's for now move down. We only have about 10 minutes, but let's kind of try to at least work through recommendation 12 and, you know, maybe even 13, but I'll give you a chance to read through recommendation 12 or new recommendation 12, which was recommendation 13. And then we'll engage in discussion on that. Okay, I know in your initial comments you had something about 13. So Alex, I'll turn to you again.
Thanks. So as I mentioned in my initial comments, OMB has questions about the underlying authorities for recommendation 13 that would require further analysis. And I guess just to clarify that a little bit, that question wasn't about ACUS authorities, it was about other authorities. Reframing recommendation 13 to be directed to agencies rather than calling for an EO would address those concerns or questions. I can go on to parts A and B if that's okay, or would you like me to just stick with the,
Yes,
okay.
please.
So with respect to 13A, OMB doesn't think that a fixed deadline is desirable given the variety of circumstances that can arise and scarce agency resources. OMB believes that this recommendation is potentially repetitive of 9D above, I guess it would now be 8D, and that recommendation can be made adequate to address the issue at hand here. If a timeline is retained, given the time required for rulemaking, a one-year period is too short. Although, again, OMB's preferred approach would not to be giving a firm time frame, we would suggest that at least a 3-year period as a best practice. A 3-year period would align with certain other statutory periods, including related to temporary rules. And then I can go on to 13B. OMB thinks that the existing good cause criteria are adequate. It is unclear to us why the fact that a rule being major under the CRA should overrule the usual good cause criteria of notice and comment being impracticable, unnecessary, or contrary to public interest. This recommendation would unnecessarily complicate good cause statements for no clear benefit. The upshot of this would be that as a matter of policy, agencies could not rely on the contrary to public interest prong of good cause for major rules. Unclear how this recommendation would permit good cause when, for example, announcement of a proposed rule would enable the sort of financial manipulation the rule sought to prevent. And that's a quotation from Mack Trucks. This seems to be a set of acute circumstances where should notice and comment be required where that type of rulemaking is major. I'll stop there for now. Thank you.
Okay. Thank you so much, Alex. So there's several comments in there. I guess we'll start with 12. The first one is that the authority to issue this to the president or direct it to the president is better directed to the agencies, if I'm understanding Alex's comment. So let me just kind of refer to you and just like start with the first one, and then we'll kind of return to the other two comments first. So the first comment with respect to 12 would be to direct it towards an agency with language that would suggest it's directed towards the agency and not the president. Is that a correct interpretation?
Yes, that's correct. So direct the recommendation to agencies as opposed to be a recommendation for an executive order.
Okay, thank you. Okay, so and we'll if you have comments on 12A and B, we'll incorporate them. But I just want to kind of incorporate into Alex's comment greater than, it would be 3 years instead of 1 year on A, would be the suggested change. And then we'll go to C in terms
Sorry,
of
if I could.
Yes.
If I could just clarify that. So.
Or no deadline would be the suggestion. Yeah.
Yes, thank you. No deadline would be our preferred, but should a deadline be included, we would suggest at least 3 years.
I got it. Sorry, but thank you, Alex.
Thank you.
And we'll turn to B as well. The B, I guess I want to sort of understand B would essentially not make a distinction between regular rules and major rules. Would it suggest like deleting B in its entirety, or is there value in keeping B in some form?
I think our suggestion would be to delete B altogether. We didn't see the value, and we think that the current good cause criteria are adequate.
Great. Thank you so much, Alex. Ron.
I agree on getting rid of B. I also want to argue for getting rid of A. And this is not related to authority. It has the ability to prescribe it, it's because it's not a good idea. And this is on the basis of comments that the administrative law section of the ABA reached in two different settings. One is commenting on a federal regulatory reform bill, and another in the model state APA, each of which proposed deadlines. And the section was against them in both contexts because things come up at the last minute. The agency finds it has other priorities or things that it gets stuck with a bunch of responsibilities that it can barely handle. But now it's got to take time and finalize this rule because the deadline is coming up, and that can lead to rushed, ill-considered results. The section thought it's really a kind of management from a year out that doesn't work very well. The section thought that rather than have a firm deadline, maybe a more palatable alternative would be to have periods of after which the agency should explain why they want to extend with good cause, and that could be reviewed, but not put a firm deadline on it because sometimes things take a lot longer than you thought they were going to take. So that was the position of the section, just don't do it.
Yeah, so that would just be generally delete recommendation 12, as I understand it.
Yes.
Yes, okay. Okay. Just make sure I'm clear on that. Okay. Miriam, and just mindful we have about 4 minutes, and I just want to just relay a message that the committee will not have final word, does not have final word on whether to go forward with the recommendation or not. The council who approved this project can override the committee and still forward the recommendation to the plenary for a vote. So the question then is, what version would that be? And ultimately, this is a question for the general counsel to opine on. So just notice as to where our authority lies, I guess. Miriam.
I mean, I agree with, in general, just removing what's now 12.
Okay.
If we keep it, and we decide to say we're going to put in a deadline, if there's an expiration date that is 6 months or less, we will not put it in the CFR. So that's something to consider if you're saying I mean, so this is greater than 1 year. It should not be greater than 1 year. If it's less than, I think it's 9 months right now, we're not going to put it in the CFR because it will basically render the CFR volume obsolete as soon as we publish it, or almost as soon as we publish it. It's something that we do for any rule that is less than that will expire within that period of time. So if we put in a deadline, it needs to be more than 1 year. Otherwise, chances are it will never even appear in the CFR. Right. It may or may not even appear in the ECFR because what goes in the ECFR is going into the CFR.
So Miriam, if I'm understanding you correctly, your first preference would be to delete the deadline consistent with Alex's comment. Alternatively, if we have to have a deadline, it must be longer than the one suggested here.
Yes, otherwise there's a great likelihood that the only way that you will find that interim rule is with the actual Federal Register document that published it. It may not ever get codified.
Okay. Thank you, Miriam. Jeff, and I recognize the time.
Okay, I'll be quick. So I do think the ACUS can make a recommendation to the White House to issue an executive order or to issue guidance, whatever, if we have something, we want them to say. I do agree that A and B, we shouldn't be recommending be put into an executive order. I think the only problem with interim final rulemaking is that sometimes agencies say that they ask for comments and then they never respond to the comments or announce what they're going to do. They just it just goes on indefinitely and there's no response. So I think that's really the biggest problem here. And maybe that's what A is intended to address, but it doesn't really do it. So, I think we should not shy away from telling the president what we think would be a good idea, but I don't think these are the best ideas.
Thank you, Jeff. So we are at noon right now. I have 2 persons in the queue. I recognize that people may need to drop off, but if David and Bill can be as brief in their comments as they can be, and then we will conclude the meeting. David.
Yes, thank you. If this recommendation is going to survive in any way, I'd like to make a suggestion for how to format it, because I'm envisioning agency attorneys in the future looking at what ACUS did in 2024 and looking at what they did in 1995 and trying to reconcile the two. So my suggestion is, if this is going to survive, why don't we style it as recommendation 95-4 is amended as follows, by adding such and such and with whatever changes. So in order to make use of this easier in the future.
Right. Thank you for that, David. And I think that, again, you will have homework between now and the next meeting, which is to read 95-4. And then, we can appropriately assess in terms of whether we should sort of think of this as an amendment to 95-4 or not, or even if it needs to be an amendment to 95-4 at all, or something just completely separate. Yes, Bill.
I would vote against deleting new 12. I think it should be amended. I think there might be things we add to it that aren't there now, but I certainly want to go forward with the idea that we can recommend to the president that he direct agencies to do things that we think are so important that the agency shouldn't just consider them, but they should be required to do them. So that's my position.
All right. Thank you, Bill. We won't make a decision on new recommendation 12 at this meeting. We've had some points that are made. We just don't have the time to actually get to that point. What we'll do, again, please read 95-4. It's linked in the chat for before next meeting so that we can discuss in terms of what we want to do with this particular recommendation going forward. And I thank you for the time. I didn't give you guys a break. You guys must be famished and thirsty and all those things, and I apologize for that. I'll do better next time. So let's plan. We will meet again on October 22nd from 10 to noon. Is that correct, Ben, on the calendar?
That's correct. October 22nd, Tuesday, same time.
Same time, 10 to 12. I will see you all then. Please submit comments that you might have prior to the meeting. Thank you all, and I'll see you guys next time.
Thanks, Patrol.
Thank you.